Children case number 058 of 2021, Gladys Cheruto Hagi versus Collins Tibet Moi.
I'm present only briefly here for reflecting. Name is Owewan, and I kindly request that request it aside because she's on her feet before High Court number 4.
Okay, Your Honor, thank you. Your Honor, we were before this court on Monday, and then you gave us the date for today, Your Honor. And on that day, we established why the client was in custody as per the orders which were given on the 24th of February this year. And Your Honor, on the two keys that I mentioned that day that were going to be met, yesterday, Your Honor, me and my colleague found our way to Kabara University with a letter, and we attached the court orders, and we managed to see the Deputy Vice Chancellor. We didn't manage to reach the Chancellor himself, and they declined to receive our letter in physical form. They returned it to us, Your Honor, and we tried to ask if we can have a physical date. They didn't give us the physical date, Your Honor. So upon returning to the office, we sent them through an email, and I've attached, it's on the file for the court file. I've put the affidavit of service and the email, Your Honor. And then on the other matter, which was to do the application for attaching the decretal sum to the estate of my client, his father, Jonathan, the matter was supposed to be for ruling yesterday in the High Court, but the matter was not ruled. He pushed the date to 31st. And as of now, Your Honor, I've not yet been mapped. I think there's an issue with the system. We tried being mapped, and we have not yet filed the application, but we're ready to file upon being mapped, Your Honor.
There is a valid judgment of this Honorable Court that was issued in the year 2022. We caused a notice to show cause to be issued against the defendant judgment debtor, and warrants of arrest were issued by this Honorable Court, wherein the judgment debtor was arrested and presented to court on the 19th of September 2024. The court, 19th of September 2024, the court, upon hearing him, committed him to civil jail, upon which, Your Honor, his erstwhile advocates filed an application to lift the committal and to negotiate the matter in the interest of the children. Your Honor, you had the application and delivered your ruling. Regrettably, Your Honor, there was still no compliance by the judgment debtor, and subsequently thereafter, counsel on record for the JD defendant right now filed an application dated the 26th of November 2024 and sought, Your Honor, dated the 26th of November 2024 and sought, Your Honor, to review and or set aside the orders that you had issued, including the judgment of the court that was delivered on the 2nd of June 2022. Your Honor, you had that application from the month of November and delivered your ruling on the 13th of February 2025, where for all intents and purposes, you allowed the prayers by the judgment debtor, defendant herein, 1, to enroll the minors at Kabarak University, Kabarak Kabarak Primary School, but declined the prayer for transfer of the firstborn minor CK from Mustard Seed School. Secondly, Your Honor, you directed that within 3 months, the defendant, at his own request, does apply a medical scheme at Kabarak Health Center that would provide for the medical needs of the minors. That counsel was trying to visit the school yesterday goes to speak towards a defendant and a father that lacks the best interest of his biological children. Your Honor, the best inheritance that the defendant can give his children is education. From the time the court delivered itself in the judgment in 2022, up to now, the defendant has never shown any efforts and or commitment to ensure that his children are properly taken care of. Yet, Your Honor, from 2022 up to now, the same grounds that the defendant has given, time in, time out, continue being rehashed before these honorable courts. That bespeaks, Your Honor, of a party or a father that is evasive of his parental responsibility as far as his children are concerned. Your Honor, the guiding principle in a children's court is the best interest of the minors. It goes without saying that the history of this matter speaks very loudly against that very interest that is enshrined under the Constitution and the Children's Act. I urge the courts not to shut a blind eye to the history of this matter that is very rich, and I urge the courts to protect these minors. This court sits as a children's court, and the best interests of these minors are paramount. Your Honor, as I submit before you this morning, or is it afternoon, my client received a letter from the school requiring the minor to go back home, that is Colin Moy, to go back home, because the child has not complied in payment of school fees. Can we really fault the school for sending the child home? Absolutely not. The choice of school was of the parents, and the court in this case gave clear orders, crystal clear orders for compliance. Your Honor, committal to civil jail is a lawful process of these honorable courts. It is provided for under the law, and therefore, there would be nothing illegal in this honorable court exercising its discretion in committing the defendant.
I shall not curtail the judgment debtor's renewed effort to pursuing the enrollment of the minor to Kabarak Group of Schools. The pursuit shall continue, and to actualize this, and as requested, I allow the judgment debtor's request to summon the members of the Kabarak trustees to shed light on the compliance of the court's directive to facilitate the enrollment of the minor to Kabarak Group of Schools. Summons shall issue forthwith for their attendance to court on the 23rd of July 2025, which summons shall be served by the defendant's counsel. In the meantime, I commit the judgment debtor to civil jail for a period of 2 weeks for clarity until the 23rd of July 2025. The decree holder shall pay his subsistence for the period. That is the ruling of this court.
I'm sick. I've tried. I've suffered since my father died. I don't live anywhere. I have asked for mercy. No one has mercy these days on an offer. I've asked the president of this country to help me. No one can help me. Gideon Moi. Last time, my young brother almost died, the last born. I'm the firstborn of Jonathan Moi, and the last born. Nakuru, Rift Valley's MPs had to get money for him to go to medical in India. Me, I'm on the streets of Rongai until my friends take me to hospital when I'm sick.
Have you tried reaching out to them?
I have tried everyone.
Who particularly have you tried to reach out
I've
to?
tried Gideon. I've tried my stepmoms. My stepmoms, I called them when I was in hospital, when my lungs collapsed, when I was sleeping in the streets of Rongai, in a place called in a Mira base where I can only stay.
Do you sleep hungry sometimes?
Yes, even for 2-3 weeks. The people of Mira base wananiwekea pesa inaitwa kwa Murugi Rongai, Murugi base. They closed me. These clothes I was bought by a very kind friend of mine called Irene Njenga, who and her children are suffering, but she very kindly.
Would you want to help your children?
I do. I want to give them whatever they want. But if my uncle has taken everything from me and my stepmom,
Do you have any inheritance?
I have not gotten anything. That's why I'm sleeping on that. That's why I was asking the president of this country, please help me. Help me, tell these people to give me so that I can help my children.